Eku Iluna, please rise. Ahea oko eko ka aha, inake, kuliana imua o kea, aha, ho o kolo kolo ki ke anahano o ka moku aina o Hawaii. E nai mai, e malio mai, I lohi ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court, State of Hawaii, draw nigh. Give your attention and you shall be heard. Inoho ilalo. Please be seated.
All right, please call the case.
Case number SCWC-19-0000261. Loyalty Development Company Limited versus Wallace S.J. Ching, individually and in his capacity as a director of Loyalty Development Company Limited. Arguing for petitioner, defendant appellant Wallace S.J. Ching is Deirdre Marie Iha. Also appearing are Edmund Safri and Kelly Wong. Arguing for respondent, plaintiff appellee, Loyalty Development Company Limited is Jonathan Moore. Argument on the merits.
All right, good morning, aloha everyone. Our proceeding today is being broadcast live on the Judiciary's YouTube channel as well as on Olelo. Counsel, are you ready to proceed? Mr. Moore? All right, just as a preliminary matter, Mr. Moore, do you have any objection or concern with Ms. Wong's participation? All right, thank you. The court is allowed 30 minutes for each side. Just to confirm, Ms. Marie Iha, you're going to start with 23 minutes, 7 minutes reserved for rebuttal, so we'll give you a warning at the 23-minute mark. Mr. Moore, you have half an hour, and we will give you a warning with 10 minutes to go. Please proceed.
Chief Justice Rechtenwald, Associate Justices, good morning. Deirdre Marie Iha, Edmund Safri, and Kelly Wong for petitioner Wallace Ching. Thank you for the opportunity for oral argument. Just last year, in the Haleakala Ranch case, this court ruled that the fee shifting provided for by the private attorney general doctrine would be nullified if, quote, fee awards are diluted or dissipated by lengthy, uncompensated proceedings to fix or defend a rightful fee claim. We respectfully ask this court to apply the same logic to the corporate indemnity statute, HRS 414-243. That is, we ask this court to rule that the required fee shifting provided for by the legislature for corporate directors include the cost of securing such indemnification, so-called fees on fees. This statute says that a corporation shall indemnify a director who was wholly successful on the merits or otherwise against reasonable expenses. The statute further defines the word expenses to include counsel fees. That's in section 414-241. In our view, Your Honors, the question presented by this appeal is whether the phrase reasonable expenses in HRS 414-243 includes fees on fees. Your Honors, the ICA gravely erred in its statutory construction by instead reading a different statute, 414-245B, to limit fees on fees only to situations with court-ordered indemnification for the underlying defense. At the same time, the ICA declined to interpret 414-243, which is in fact the source of the mandatory indemnification that is created for corporate directors by statute. You can see this at pages 4 to 5 of the ICA's summary disposition order.
Is it your position, counsel, that we don't even need to get to 414-245? I think I heard you say the question is whether fees on fees is considered reasonable expenses under 414-243.
I think that is the central question, Your Honor, to define whether reasonable expenses in the mandatory indemnification provision includes fees on fees. But I think to fully address the ICA's decision, if you disagree with their interpretation of 245B, presumably you would want to say something about that. I don't think you would actually have to arrive at the result that we're looking for, because I think it turns on the scope of the right of indemnification created by the legislature. And if you look at 245B, and this is where we think the ICA's fundamental error is, 245B is not the source of the right of indemnification. That unquestionably comes in 243 that says the corporation shall indemnify. That is the source. 245 is a procedural statute, Your Honors. If you read the whole thing, it outlines the circumstances in which the court how is a court going to go about ruling on a motion for attorney's fees or advance of expenses under the other portions
But
of the
isn't
statute?
the real hang up, they're saying it's not court-ordered indemnification, isn't the language hanging all of this up?
That is the basis of the ICA's decision, Your Honor, but the reason that we think that's incorrect is because there's no part of 245, which is the provision the ICA relied on, that purports to weaken the grant of indemnification, which the ICA declined to interpret the statutory source of the indemnification. And even 245 says that. 245 is a statutory implementation of the rates created elsewhere in that same subpart.
Right, and this whole statutory scheme is trying to make the director whole, isn't that really what they're
That's
trying
correct,
to
Your Honor.
achieve?
It is a remedial statute, and we cited some of the persuasive authority because this is a novel question of law for our jurisdiction. But you have to look to the purpose of the statute when you're saying to make the director whole. The purpose of the statute is when to offer to indemnify corporate directors is to encourage responsible and competent people to serve as corporate directors so that they know they're not putting their own savings and their own assets on the line in order to serve as a director of a corporation. So it's a remedial statute, Your Honor. You can see that in the comments to the Model Business Corporation Act. When Hawaii adopted the current law, which is Chapter 414, in 2000, we were adopting the Model Business Corporation Act, and the comments to that explicitly say that that is the reason why you have to have corporate indemnification. That's why it's desirable as a matter of policy. So even though I don't have existing case law from this court, because this is the first time that we're considering this question, that is, I think, strong persuasive authority for intent because we were adopting that model law. So the comments to the model law, I think, are quite helpful. And then along the same lines, we've cited as persuasive authority the case law from Delaware. And the one case that we point you to in particular is the Stifel Financial Corporation case from the Delaware Supreme Court in 2002, where they said that even though their statute does not explicitly mention fees on fees, they were still going to interpret it to include fees on fees in order to make that right of indemnification whole, just as Justice Devins just mentioned. So I'm sure you're aware, the Delaware courts are the powerhouse of corporations law, but what struck me for purposes of today about that logic is it's exactly the same as this court's logic in Haleakala Ranch. In Haleakala Ranch, you said that the fee shifting for the private attorney general doctrine would be incomplete. It would be diluted. It would not be complete with the absence of fees on fees.
What's your response to the ICA's argument that the sort of default rule is that each party bears their own attorney's fees? And so you've got a statute that, at least viewed in its, just by its standing alone, seems to identify a process that wasn't followed in this case in the sense that there wasn't court-ordered indemnification.
Right. So the ICA does identify the American rule, the standard that each party bears its own attorney's fees in its summary disposition order. And as outlined in our certiorari briefing, we think that that's erroneous because the decision to provide for fee shifting has already been made by the legislature in enacting 414-243. So it is not a question whether fee shifting should exist. That public policy decision has already been made. So the question for this court is to interpret the scope of that provision. And so I think that that was sort of misplaced. And again, the ICA pulled the phrase court-ordered indemnification out of 245 to functionally limit 243 without saying that that's what they were doing. But here's the thing. In order to, under the logic of the ICA's decision, even if my client was inclined to accept the $177,000 that LDC finally offered for the cost of the underlying defense, we would have had to say no and litigate more in order to establish the right to fees on fees. And in my view, that interpretation is absurd and contrary to the logic of this court's case in Blair versus Ng, where you're concluding that you shouldn't have to keep litigating in order to establish your right to fees on fees. So to me, the scope of the statute that establishes the mandatory indemnification, which is the scope of 243, what's included in the phrase reasonable expenses, should be the same regardless of how you get there. Those reasons.
Well, in theory, I guess it could work out where you could expend more trying to enforce than what the indemnification is actually worth. I mean,
you could,
happen.
but because exactly the reason stated in Haleakala Ranch, you know, the money is fungible, right? So it's going to be diluted, and if they'll run up your costs to try to secure this right that you're entitled to, That's what the Delaware Supreme Court warned against,
What
where they
about
said,
what about their argument though that Mr. Ching wasn't wholly successful?
okay, so that's the circuit court's error, Your Honor. The ICA did not reach that question. The statute says wholly successful on the merits or otherwise. That's the phrase from 243. It's very
I'm more curious about the otherwise.
The otherwise, right, yeah, so am I. He definitely didn't succeed on the merits because the dismissal in front of Judge Encino was basically for the improper use of the deck action statute, right? So it was a procedural defense. So in our view, and we've cited case law, again, persuasive authority from around the country, that dismissals of on the merits or otherwise is intended to include procedural defenses. Our statute requires him to be wholly successful, but he also meets that requirement because the dismissal that made by Judge Encino in 2016 was for the whole case.
But without prejudice though.
But, well,
Did
that's
that
correct,
make a
Your Honor.
difference?
Howard, that's correct. It was without prejudice. However, again, the MBCA comments can be helpful here, where the comments say that the wholly successful means it has to dispose of the entire proceeding. So that part's a little easier. When they describe what does it mean to be wholly successful on the merits or otherwise, they say any basis that does not result in a finding of liability.
Well, so I mean, are you suggesting that or otherwise? I mean, it seems like it covers everything. I mean, any win, let's say, is covered. It's everything. It sounds like what your point is.
I believe so, Your Honor, because I'm not really sure what else it could mean. I mean, it's clearly on the merits or something else, right? But you have to be wholly successful. So let's say it was a multi-count complaint. Only one count of a multi-count complaint was dismissed. That would not be good enough. It would not fall under 243. But in our case, there was one count for a declaratory judgment filed by LDC against my client. One count, and that entire complaint was dismissed in full by Judge Encino, and he found that that LDC was trying to get the circuit court to issue an advisory opinion. That was his rationale.
If they had moved themselves to dismiss the case without prejudice before the court ruled, would you still be successful on the merits or otherwise?
I think so, Your Honor, because the Ranger insurance case from this court says that a voluntary dismissal can still count as a victory for purposes of attorney's fees. So the purpose of that would be to discourage people from filing, ill-considered lawsuits.
That would be then otherwise.
Or otherwise, right? So I think the purpose of the or otherwise is deliberately broad. And there's also persuasive case law, again, cited in our briefing, that you don't look behind the result. You don't do all the wheres and high fours and soul searching and, you don't try to puzzle through all of this. You just look at what happened. And we know what happened because Judge Encino said so. He said he's not in the business of issuing advisory opinions, and that's what law firms are for. That's in the transcript from the 2016 hearing. So in our view, if you agree with us that the ICA was itself doing statutory error, then you reach Justice Devin's questions, which is the circuit court's different statutory error, which is on whether Mr. Ching was wholly successful on the merits or otherwise. And we believe he was, because
You think that just is by the nature of the disposition of the case and what happened up till then doesn't matter? Because I know imagine Mr. Moore is going to argue that Mr. Ching flip-flopped multiple times and that there was sort of a suggestion that when it was convenient to say there wasn't a live dispute, that's where he was at, and then it sort of changed. I'm not saying that's right, but
that has been their argument, Your Honor. And the reason that I think that doesn't matter is because that argument depends on a misunderstanding of the nature of Mr. Ching's position. And we clearly articulated this in every court that we filed in. Basically, Mr. Ching had a disagreement, a difference of opinion with other members of the LDC board. I am quite certain that happens every day of the week on corporate boards. That's all that was happening. The existence of that without more of a concrete issue does not mean you can seek a declaratory judgment. So his position has been consistent the whole time. He still thinks today what he thought before all of this started. He's not convinced that the 1990 amendments were validly made to LDC's articles. But that doesn't matter. Whether you can go to court has nothing to do with the fact that there's a difference of opinion between members of a corporate board. Whether you go to court under ASATO, this court's controlling case law, depends on the existence of a concrete dispute. So, for example, let's say there was a transaction and the validity of that transaction with some, outside third party depended on whether these, provisions of the article were valid. Then you've got a concrete dispute. If you look at the briefing, LDC admitted that there was no specific transaction that they were looking to litigate about. It was just about the existence of this disagreement. So in my mind, Your Honor, there is no so-called flip-flop because it's just a misunderstanding of the difference between having a disagreement on a corporate board and how you properly go about using 632-1, the deck action statute. So we explain that in all of our briefings. So I see no change on that. However, even if you thought that Ching's decision to, successfully invoke a procedural defense once he's been named somehow amounted to a change in position, it still wouldn't matter because he won. And all you look to is the result, which is exactly what Judge Nacino said.
Was there any counterclaim or anything like that? No counterclaim, right?
Not at all, Your Honor.
Okay,
It was
would
just a
that matter?
one-count complaint.
Would that matter?
Um,
Maybe just in terms of calculating it. I mean, the statute provides for,
Well, I think the mandatory entitlement to indemnification, you would still have to be wholly successful on the merits or otherwise. However, the statute, the same subpart, also has permissive. It also has kind of a, in the interest of fairness provision where there's some flexibility for the judge. So if you went into a factual situation where there was some dispute involving let's say a counterclaim of some kind, I think you would end up with a little messier situation than what we have. That doesn't mean that there automatically would be no indemnification under one of the other provisions. And then we also believe that Mr. Ching is entitled to indemnification under the LDC articles, right? And again, we've made this assertion over and over again. So the articles and the statute are not like a complete overlap. If you imagine them as a Venn diagram, there would be situations where somebody may qualify for one, but not the other. But here, Mr. Ching falls under both, okay? So the one thing I wanted to point out, which may not be completely clear, is that for both of those entitlements to indemnification, they exist simultaneously and both of them are explicitly not exclusive. So by statute in 414-250, which actually states that the right of indemnification, quote, provided by this subpart shall not be deemed exclusive of any other rights, unquote. The statute says that. The articles say something very similar with the same effect. Article 5, Section 10 of LDC's articles, which states that the right of indemnification under the articles, quote, shall not be exclusive of any other rights to which those seeking indemnification shall be entitled, unquote. So I'm certainly not suggesting he would recover twice, but he has two independent legal bases to seek indemnification because we believe he qualifies. The definition, the operative words in these two provisions are remarkably similar. The statute says reasonable expenses, with the word expenses defined by statute to include counsel fees. The articles say reasonable expenses, including attorney's fees. So at the end of the day, we think the same logic should apply, meaning the right of indemnification is rendered incomplete at the risk of dilution, exactly as stated by this court in Haleakala Ranch, if you do not include fees on fees.
Of course, another reading would be that the reasonable expenses have to include fees because that's what you incur in defending against the claim.
Well, yes. I mean, there's
perhaps it's just stating the obvious.
right. No, that's true. I mean, I suppose you could have some other connected fees, but yes, that's going to be the bulk of the expense that is incurred in a lawsuit, right? I think we know that. But when you go back to the statutory interpretation, you end up, like I said, exactly where the court landed in Haleakala Ranch, because in my view, once you have an entitlement to fee shifting, once you've got it, kind of regardless of how you got there, that you have the same problem, meaning that the fees on, if you don't include fees on fees, you risk rendering the right of indemnification, the right of fee shifting, wherever it comes from, you risk rendering that right incomplete if you don't, require that fees on fees be included within it.
How do you address or explain that in 414-245B, it does include the language, court-ordered indemnification? What is the significance of that language?
Thank you, Your Honor. So I think 245, if you read the whole thing rather than just that one sentence, it's a procedural statute. So it's explaining sort of how a circuit court goes about deciding a request for fees that's made in front of it.
It's kind of anticipating, in fact, a request for fees under 414-243.
It is. So
right?
I have read it, and in fact, if you look at our briefs, we cited this statute, not the primary one, because we think 243 is the source, but we think the statute supports our inclusion of fees on fees within it because it's consistently part of the statutory structure. But if you look at 245A and back up a subsection for a second, it's considering different grounds by which the circuit court could order indemnification or advancement. So if you, for example, you look at A1, the court could order indemnification if the court determines the director is entitled to mandatory indemnification under 243, or order indemnification or advance if they're qualified under this other provision. Or there's a whole other one which reads kind of like a catch-all because it says fair and reasonable. I think that might be the kind of circumstances outside of our thing. If you look at 245B, the language that the ICA relied on, the first sentence is saying that the court shall consider fees on fees if it falls under A1 or A2. But the next sentence says may consider fees on fees if it falls under 3, the fair and reasonable catch-all, which doesn't apply here. So to me, this language is describing the scope, the differing scope of the circuit court's discretion for the different procedural mechanisms by which the request for fees or advancement, indemnification or advancement may arrive in front of the court under A1, 2, or 3. It's not limiting the mandatory right of indemnification under 414-243. If anything, when you read these two sentences together, where the first one says shall and the second one says may, 243 falls under shall, right? So then the reason why it can't be that only if you seek the underlying court-ordered indemnification can you get fees on fees is because it leads to the absurd conclusion, which is what the natural consequence of the ICA's decision, that parties are literally forbidden from partially settling an attorney's fees dispute. Because under the ICA's view, because my client was prepared to accept the $177,000 as the cost for the underlying defense after Mr. Crumpton made that decision for the LDC board, he was prepared to accept it, and he did. It was not everything he asked for, but basically functionally a settlement with the understanding that the fees on fees was not included. According to the ICA, even if we thought, you know what, this is a decent outcome, we would have had to say no, we would have had to litigate more, take it to the circuit court, and then let's say hypothetically, the circuit court then said, you know what, I like Mr. Crumpton's number, $177,000 sounds good to me, then we would have been entitled to fees on fees. Just because we went to circuit court to ask for the same thing that we would have agreed to earlier. It's totally counter to the whole notion of encouraging parties to settle. Attorney's fees motions, as we all know, are burdensome for everyone involved. And if you want to encourage a partial settlement, then the scope of the mandatory indemnification under 243 should be the same regardless of how you get there, meaning that if you get there through an agreement, you get there through the articles, because Mr. Crumpton decided on behalf of the LDC board that he was entitled to fees, that Ching was entitled to fees under the articles, and they said they would pay, just like he said. And you want to encourage us to do that and limit the scope of the filing before the court. The result of the ICA's decision would have been for us to file an attorney's fees motion twice the size of the one that was there, as opposed to being able to say to the court, we settled this partial issue, we have this one remaining one. So in my reading, the idea that you avoid absurd constructions of statutes, it's squarely applicable here, because it's not where the right comes from. There's nothing in 245 that purports to weaken what the statute itself says is the mandatory indemnification under 243. Well, I'm about coming up on my rebuttal time, so maybe now's a good time.
No questions from the court, so
Okay.
we'll hear from Mr. Moore.
Okay, thank you so much.
Thank you.
Thank you, Chief Justice and Associate Justices. My name is Jonathan Moore. I'm representing Loyalty Development Company in this matter. It's a real pleasure to be in front of the Supreme Court for the first time. I'm going to start by backing up to how this matter came to the trial court in the first place on the fee issue. And that is that the company and Ching went through a private process set forth in the Articles of Incorporation, whereby the company appointed an independent attorney to assess Mr. Ching's fee claim arising from the underlying declaratory judgment action.
I'm having a little bit of
Oh,
problems.
is it better if I stand here?
Yes, maybe you can lift the microphone up a little bit more.
Is that all right? Oh.
Yeah.
Okay. So that private counsel who was appointed was Charles Crumpton, and he went through Mr. Ching's fee claim, and in his written opinion, he concluded that Mr. Ching was not wholly successful on the merits because of that change of position that he had taken, and because of the fact that what Mr. Ching had achieved was a dismissal without prejudice. And he awarded the $177,000 in fees that he thought were reasonable. But there was no finding that he was wholly successful on the merits and therefore entitled to mandatory indemnification.
So he ruled on the articles or on the statute?
He ruled on the articles,
Right.
but he did find in his opinion that Mr. Ching was not wholly successful on the merits.
He kind of reached out and talked about the statute, although
Correct.
he didn't have to rely.
And then he believed that he did not have the right to award fees on fees for Mr. Ching's expenses in participating in that private process to settle the fee amount. But as a sort of advisory opinion, he concluded that if Mr. Ching were allowed fees, he would be allowed about $44,000 in fees. Following this, Loyalty Development they told Mr. Ching they would give him a check for $177,000 with no strings attached, that he was just going to get that. And they said they would give him the $44,000 extra if he would agree that that settled the matter completely. Mr. Ching didn't agree, and then he filed his motion for fees in front of Judge Ochiai. So then we were in front of Judge Ochiai, and this was in, I believe, November of 2016. And Judge Ochiai also found that Mr. Ching was not wholly successful on the merits. And he
at that point, I mean, what else could he have done? I mean, he moved to dismiss. Judge seemed to find there was no real controversy being alleged, and the case gets dismissed, I know, without prejudice, but in order to come back, you'd have to file a brand new claim, and you'd have to have more than what you had the first time around. Why isn't that wholly successful? Maybe not on the merits per se, but otherwise?
I understand the question, Your Honor. So what Mr. Ching did in the motion to dismiss was he said that there was no sort of live claim that was ripe for determination.
Failure to state a claim, right? It was a failure to state a claim.
Right. That there was no dispute that would put it subject to the Declaratory Judgment Act. And what he said was that the majority directors of Loyalty Development had the right to vote however they want and cause the corporation to take actions according to majority vote. But that's a very different position than the position he had been taking previously, which was that the majority directors in certain conflicted transactions, that they were purporting to cast votes under the conflict of interest provision.
Wasn't he actually saying, I have this opinion, but I'm outvoted, so it doesn't really matter. It's not going to go anywhere.
But his opinion was that these directors did not have the right to vote because they were conflicted and the conflict of interest provision was illegal.
But that he's going to get outvoted, though.
But his opinion was that they had no right to vote at all. And so then suddenly in the motion for dismissal, he says that there's no dispute because they can vote any way they want. So for the first time, he's saying that they can vote. And that it's just a difference of opinion, whereas before his opinion was that they had no right at all to vote, so that any actions that they took pursuant to those votes were void.
Why isn't, when the case gets dismissed, why isn't that wholly successful? Because no matter what happened during the interim, the result was that it's gone.
That case was gone. The motion for the complaint for declaratory relief had been dismissed, and I would grant and concede that under 607-14 that would make him the prevailing party. But 607-14 is only concerned with who is the prevailing party, and it speaks of the loser and the winner. And it does not have any of the language that's contained in 414-243 that talks about wholly successful on the merits or otherwise. That language is nowhere in 607-14. So I think any of these cases that we're looking at that talk about a dismissal with prejudice being prevailing on the merit or prevailing for the purpose of attorney's fees, if those cases are interpreting 607-14, that's a lower standard.
Would it have made a difference if the case was dismissed with prejudice?
I think so, because I think that would make it wholly successful otherwise.
How does that distinguish it, though? Why would that make a difference?
Because if it was dismissed with prejudice, it would foreclose LDC from ever again bringing a claim for declaratory relief on the question of the validity of its articles of incorporation. And a strange thing about
It would only foreclose the type of claim that was brought where the judge found there was no real claim being asserted. But you could thereafter come back, even if it was with prejudice, and raise a live controversy. Wouldn't that be an option?
Well, I mean, one strange result of the court's order of dismissal and the court's Judge Nacino's interpretation of the declaratory judgment statute and when an action is ripe for a decision under that statute is that Ching all along had the right to bring a lawsuit against LDC for any of the transactions that it had if it had signed a lease that had been voted on by the majority directors pursuant to their interpretation of the conflict of interest provision in the articles, then Mr. Ching had a live cause of action against Loyalty for taking steps that were illegal and it was not permitted to do, and he could file a lawsuit to void that transaction. But at the same time, suddenly, LDC doesn't have the ability to just get a declaratory judgment in order to determine whether those articles in its or those provisions in its articles are legal or not. So I think if Mr. Ching had gotten a dismissal with prejudice, that would be a very different form of success, not on the merits, but it would be wholly successful.
It seems like both of you are arguing the result is the key. I mean, Ching is saying, hey, what's the bottom line result? And you're saying the bottom line result, if it was with prejudice, you would not win. And I guess, the purpose of this statute is to indemnify directors, when they're facing these types of suits. And the court here made comments that, hey, it's preemptive, it's, an advisory opinion, it's not ripe. I mean, essentially the court's saying, you're wasting my time, get out of my courtroom. And isn't that enough? Isn't that the otherwise that we're looking at here? And if not, why not?
In this particular set of circumstances, Mr. Ching was a director of LDC, and he had as much of an interest as any director or shareholder in LDC in having its articles clarified and made so that everyone who was dealing with them and every outsider who was dealing with the company could have confidence that any transactions they entered into were sound. And what Mr. Ching did was clearly change his position in the course of that litigation so that instead of saying the directors have no right to vote at these hearings because the provision which they purport to have a right to vote under is illegal, he's saying the directors can vote however they want and the corporation will act on those grounds. So I think
Is that really inconsistent? So he goes from saying And isn't that just kind of like shrug your shoulders? Well, you know, that's my position, but they can outvote me, which is not quite the same thing as saying, now I believe that the provisions are okay. Those are two different points, it seems.
I agree, he never said that now I believe the provisions are okay, but he was taking the position that the directors could vote and the corporation could act on those votes. And however, then as soon as,
If you want to be unlawful, you can vote and vote me down, I guess is what he's saying. I don't know. That's your good faith belief. Nothing I can do about it, which is his argument for there's no live controversy. Are we litigating whether there was a live, you know, whether Judge Nacino's ruling? We're really
no,
not.
I'm in agreement on that it's not an issue in this appeal whether the dismissal was correct or not. The issue in this appeal is whether, well, there are several issues in this appeal, and one of them is whether the dismissal was wholly successful on the merits or otherwise for Mr. Ching. Turning to the point of whether the indemnity provisions in Chapter 414 are part of this sort of broad public policy to ensure that the directors have full indemnity and that their right of indemnity is not hollow. Mr. Ching has cited to the trustees of Estate of Bishop v. Au, which is the unpublished ICA opinion, and then the Access Trails Hawaii versus Haleakala Ranch from this court. In the trustees of Bishop Estate case, that case dealt with HRS 607-14, which, as I've pointed out, has a completely different standard than 414-243 in terms of prevailing party versus wholly successful on the merits. And then the Supreme Court case, the Haleakala Ranch case, dealt with the private attorney general doctrine. So neither of those cases addressed 414-243. So Mr. Ching is asking that the broad policy of full indemnification that's not hollowed out that is articulated in those two cases be imported into our interpretation of Chapter 414 and its provisions. And what I would point out there is that HRS Chapter 414-249, which Mr. Ching actually cited to in his ICA opening brief, that provides that a corporation, by a provision in its articles of incorporation, may limit any of the rights to indemnification or advance for expenses created by or pursuant to this subpart. So rather than create this broad policy that directors must be fully indemnified in all respects at all times, the drafters of Chapter 414 allowed a company to limit and conceivably entirely eliminate a director's entitlement to indemnification. So when we turn to HRS Chapter 414-245B and that language about court ordered, Mr. Ching's position is that no way can we interpret that statute to be a limitation on his right of indemnification, because that hollows out his right of indemnification, and there's this public policy that...
Look, can I ask you about that? You know, speaking about public policy, I mean, public policy, you know, law also favors resolution by settlement. Mm-hmm. And so to the point that Mr. Ching's counsel makes is that trying to keep these disputes out of court, get them resolved, and you know, not burden the courts with all of these types of cases. And that seems to be what happened here through the mediator. And now your position is that because that was resolved, he accepts the amount. He now, because that was not court ordered, he now gets nothing more. And even though he had a fight to go get that indemnification.
He fought to get that. I don't know if fight is the right word, because he presented a claim to the counsel, Mr. Crumpton, of over $300,000 for approximately 2 months of work in the declaratory judgment action. And Mr. Crumpton brought that down to $177,000 because he thought that was what was reasonable. When we went to
And
Judge,
he also applied in a sunset.
Hmm?
He also did in a sunset application as well.
you're talking about the $44,000
Right,
advisory.
fees on
opinion.
fees.
Right, and he did that, and LDC offered to pay that. But then when we got to Judge Ochiai's court on the motion for fees on fees that Mr. Ching filed, Judge Ochiai pointed out that he's only entitled to reasonable fees. And given the outcome of the underlying case and what had occurred there and the vast overstatement of fees that he had presented to Mr. Crumpton, he said that $177,000 was more than enough to compensate for the level of success that Mr. Ching had achieved. So the trial court was looking at the reasonableness of what Mr. Ching had done in terms of accumulating fees in front of Judge Nacino and in front of Mr. Crumpton, and he found that $177,000 compensated for all of that.
But did he rule that included the portion of the fees on fees?
No, the order did not state that specifically.
Right, that was just for the underlying indemnification.
What he said was that he's been more than compensated for
what?
For the level of success he achieved in the underlying action. And
Right, but that amount only represented the
he-
indemnification amount.
Correct. Judge Ochiai's, I didn't want to imply that his decision said that the $177,000 specifically also covered the fees for.
No, I didn't take that. I was just seeking clarification. Thank you.
When it went back to Judge Ochiai on Ching's motion for the fees on fees, if I'm understanding the record, the request was for 191,000 as opposed to the 44,000?
Correct.
Okay. And in terms of the issue before us is, an interpretation of Chapter 414, whether it's 243 or 245, and the entitlement to the fees on fees, the question of the amount, I guess, would still be up for litigation, depending on which way this, if we were to determine fees on fees were proper.
If I understand the question, you're asking if this matter were remanded to the trial court, would it be a live issue as to the amount of the fees?
I'm just trying
and
to
the
get a
reasonable-
handle, right? on
Yes, because
the difference between the amounts that we're talking about for the fees on fees.
And Judge Nacino never did a line-by-line read of his fees to determine whether they were reasonable. So I believe that if there,
Judge Ochiai.
I'm very sorry, Judge Ochiai.
Right, so there would presumably, if we were to think that the possibility of fees on fees existed, there would be a remand for someone to go comb through and say whether 191 is reasonable or the fees are excessive or there are duplicate billings or whatever. That
Yes.
hasn't happened yet.
That has not happened.
In the Article 5, Paragraph 7, would you consider the fees on fees as an expense incurred in connection with the defense of the case?
The article is silent on that. It doesn't, there's no.
Well, it says including attorney's fees.
It says including attorney's fees, but that's talking about attorney's fees in defense of the matter in which the director was sued.
It says in connection with the defense. Does that include fees on fees?
I would submit that it does not, because the articles have a separate provision for how to settle indemnification disputes that includes the appointment of an independent counsel such as Mr. Crumpton. And so I think that if there were anything about fees on fees, it would be included in that provision rather than in paragraph 7.
I'm sorry, you're arguing that the articles don't provide for fees on fees?
The articles are entirely silent on fees on fees.
Well, doesn't Article 5, Paragraph 10 say that loyalties articles expressly preserve any statutory right to indemnification?
Yes, it says that these provisions are not exclusive to any statutory right to indemnification that a director may have. So it's clear that he could go to court, and then we run into 245B, which requires the court ordered. So one thing that I think opposing counsel and I are in complete agreement on is that this is an unsettled issue of law.
I'm sorry, say that again?
I said one thing that I think I can completely agree with opposing counsel on is that this is an issue of law that has not been settled.
Okay.
And if there are no further questions, that's all I have, Your Honor.
All right, thank you for your argument.
Thank you very much.
Ms. Marie, your rebuttal.
Thank you, Your Honors. If I could, I'd like to go through some of the questions that came up during opposing counsel's presentation. Justice Stebbins, you asked whether our motion to dismiss was a motion under 12b-6. Yes, it was, for failure to state a claim, meaning it's an improper use of the declaratory judgment statute. The lead case on that, still good law, is Asato, meaning that you cannot use the deck action statute to just get an advisory opinion from a
What's your
circuit
position
court.
if it was dismissed with prejudice and a controversy then, or what would be considered a live controversy came up? Would they be able to refile a new claim on that?
Okay, so your question is if it was the exact same dismissal of the same claim or the same complaint,
Well,
but
it's-
with prejudice instead of without?
Yeah, it seemed that Judge Nacino viewed it as purely advisory, and he wasn't gonna go there, he dismisses it. If he dismissed it with prejudice and now a new suit is filed and there's a controversy actually alleged, would they be precluded from filing that?
I don't think so, Your Honor. I don't think the with prejudice versus without prejudice distinction is particularly helpful. I think the real distinction is whether there's any attachment of liability, exactly as the MBCA comments say. But to further respond to your question, I think whether something is typically dismissed with or without prejudice has more to do with the nature of the defense, procedural defense asserted, than it does to do with anything else. So in your situation, if the dismissal from Nacino was the same, and the only difference was it says with prejudice, it would not be an accurate read of his basis for the dismissal if there was a concrete dispute over the legitimacy of a specific transaction. People have skin in the game.
That's exactly why he left it open, right? I think
Yeah,
that's what
you
he
would,
stated on
and
the
I think
record.
so. So for example, let's just take some hypotheticals. If you had a totally different case and then the dismissal was on statute of limitations ground, that would be with prejudice because nothing can ever change about that. If it was untimely now, it's going to even be more untimely 2 years later. But for our situation where it's an improper use of the declaratory judgment statute, there could be some new factual situation, right? And we said that in LDC's opposition. If you look at their opposition to the motion to dismiss, they said it was not about a specific transaction. So they're not in a position to say, well, Mr. Ching should have sued. Mr. Ching never wanted the lawsuit to be filed. He asked them not to. Then he asked them to dismiss it and they wouldn't. He asked them to go to arbitration and he wouldn't. He never wanted to litigate this issue. LDC's position in response to our motion to dismiss was that it wasn't about a specific transaction, which amounts to an admission.
I couldn't hear the last thing you said.
I apologize, Your Honor. LDC's position in its opposition to our motion to dismiss was that the dispute was not about any specific transaction, which amounts to an admission that Judge Nacino was ultimately correct, that there was nothing concrete.
I don't think the merits of the dismissal are before this court.
That's correct, Your Honor, because, and I
Right.
agree with my opposing counsel, the dismissal order was rendered appealable by the entry of the final judgment consistent with Jenkins, but LDC did not appeal. So there is no question before this court about the correctness of Judge Nacino's dismissal order in 2016. It is what it is in the record. The rub of the appeal has to do with the consequences of that order for the application of indemnification. I agree. In terms of Mr. Crumpton, I think it's very important to clarify, because there's been some confusion, especially in the circuit court record. He was hired by the LDC board unilaterally. Mr. Ching never wanted to do that, but he was hired to make the LDC board's own decision. He's
But the
not an
articles
arbitrator.
provided for that, didn't it?
What
The
was that?
articles provided for that.
They do,
procedure.
Your Honor. So the articles do provide for it. So I'm not suggesting that they couldn't do that. But there's been some description, especially in the circuit court record, that this was a proceeding, that he was acting something like an arbitrator. No, I mean, there was some degree of formality in terms of the LDC and Ching, sort of briefing the issue for Mr. Crumpton's benefit. But he's a private attorney speaking for the LDC board. So you can consider his letter if you like, but it has no effect at all. It's not a legal ruling any more than an advice letter that I send to my client tomorrow that somehow winds up in a record on appeal is something that the court would be required to consider. So I think that's important to understand. Mr. Ching did not ask for that, and that's part of the reason why the cost of his fees on fees was so much, because the LDC required him to participate in this detailed process. There's responses and SIR replies, and all that takes time. And anyone who's worked on an attorney's fees motion can tell you it's not easy to put those together, and it takes time. So that's part of the reason why by the time we got to Judge Ochiai, there was a lot of time reflected, because LDC required Mr. Ching to go to Crumpton and present his point of view so that Crumpton could make the decision for the LDC board. So while it's interesting sort of procedural background, it's not binding in any way, right? In terms of, I think we addressed the with or without prejudice question, Your Honor. In terms of the result being key with which Your Honor asked, I think that's correct. The result is key, and that's deliberate. And we quoted persuasive case law again throughout our briefing. It's not intended that you open up some sort of soul-searching analysis about why everybody did what they did. That would just open up some kind of mini trial. I mean, you can imagine that that would very rapidly spin out of control. You just look at the results. Who won? So when my opposing counsel indicates that there's some kind of meaningful distinction between a prevailing party under the Assumpsit statute 607-14 and prevailing on the merits or otherwise under our statute, I don't think that that's a meaningful distinction at all. Because if you look at the logic of this court's decision in Blair, is that you should be able to get the benefit of a procedural defense. And so if you win, you win. For whatever reason it happens to be, would bring you under the or otherwise, in my view.
Does the $191,000 in fees that you sought after Mr. Ching went back to Judge Ochiai, does that include all of the fees incurred in the activity before Mr. Crumpton?
It does, Your Honor. It runs from what happened was that following the dismissal of the hearing on the dismissal in front of Judge Nacino, LDC asked Ching's counsel, would you send us a letter rather than filing a motion? And we said, sure. So then you look in the record, this is attached to our motion for attorney's fees, will show the parties went back and forth attempting to resolve the fees issue for months with letters. Then LDC unilaterally decided that they were going to have Crumpton do it. So by the time we got to Judge Ochiai with the motion for fees on fees, that included all the time that LDC required Ching to expend in order to inform the counsel that they had hired to make the LDC board's decision. So they're going to object to how much it costs, but they're the one who required that.
So is there a combination of authority that you're asserting? I mean, is it just 414, 243 for the fees on fees? Are you arguing under the articles as well?
I think it should be both, Your Honor, and essentially because if you look at the legally operative language of HRS 414-243, which is reasonable expenses, where 241 defines expenses to include attorney's fees. And then if you look at the articles, it says reasonable expenses, parentheses, including attorney's fees. So those words are basically substantively identical. So, and then if you agree with our logic that the remedial intention to make whole a director is the reason why the statute was enacted, why would the provision of the contract that uses the exact same words be interpreted any differently? Essentially, right? So, and I forget who it was, but somebody asked a question to my opponent. Yes, Your Honor.
So Crumpton decided the amount of fees that was appropriate, both for the action itself, right? I'm trying to understand. You can answer the question. So the 171 was Crumpton's determination, adopted by the board, of what it costs to defend against the action. Is that correct?
That's correct, Your Honor. Crumpton, on behalf of the LDC board, determined that $177,000 was the reasonable amount for the underlying defense. And my client elected to accept that, essentially a partial settlement, right? There was an advisory paragraph in which Crumpton erroneously decided that Ching's request for fees was a claim. It's not a claim at all. It's a remedy for a successful defendant. And he also said it was a sumsit. Totally wrong, because the underlying case under Leslie, the essential character of the case, it was a DEC action statute. So that he did make that statement. We were offered additional funds. We turned it down because he was totally wrong on the law multiple times over, and it was way off from how much time it took us to secure the 177,000 from LDC.
As part of going to Mr. Crumpton, you also put in the amount of time, or put in for the amount of time it took to go to Mr. Crumpton. Is that
I
for
don't know the
190?
exact end date, Your Honor. Like, I couldn't tell you from right off the top of my head the exact end date. However, we did ask the entire time. We asked to be recompensed for the underlying defense and for the time it took to secure that right. And if you look at the record, and this is one of the reasons, the risk of dilution under Haleakala Ranch, you don't have to hypothesize. Look at this record and you see the lengths that Ching had to go to before we finally got to that 177,000. And you see why fees on fees has to be included, because they can just wear him down by making it cost too much to try to enforce what should be a statutory right. If I could conclude, Your Honor.
Just wrap up. Thank you.
Thank you so much. Your Honors, we respectfully request that this court vacate the ICA summary disposition order and its judgment on appeal, vacate the circuit court's findings of fact and conclusions of law on the attorney's fees and its judgment, remand to the circuit court with direction that Mr. Ching is entitled to fees on fees under both the statute and the articles. And ideally, the reason for the dismissal is as stated by Judge Nacino. Thank you very much.
All right. Thank you to both our attorneys for your argument today. The court will take this matter under advisement.
Thank you.
E ku iluna, please rise. Ua ho'o malolo ia mai ne kea aha ho'o kolo kolo ki ike hana hana. This Honorable Supreme Court is now recessed.